This morning, doomsday cult mom Lori Vallow Daybell is in the spotlight because her trial starts in a matter of days in Arizona. And guess what? She's representing herself. She appeared in court on Tuesday to discuss the status of some outstanding discovery requests and the trial logistics. And Lori told His Honor that she's anxious to get to trial and doesn't want any delays.
This is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
So how did Lori handle that with His Honor? How do you think she's doing as her own attorney? We thought it'd be great to have our legal eagles grade her. Let's bring in criminal defense attorney and civil rights attorney Casey Early and criminal defense attorney and former prosecutor Franz Borghardt on this. Okay, so let's start with how she doesn't want any delays, even if it means giving up that expert witness, her expert witness, somebody who could be favorable to her. Franz, I see you scratching your head. Will you start us off? How would you grade her on that?
I think she gets an A+ if we're trying the case on Mars, which we're not. So, okay, look, she's not going anywhere. She's already doing a significant jail sentence. Why not continue the matter? Why not get your expert? This just looks really stupid. Like, nobody's trying to rush her into a trial. So I'm going to give her a D- on this one, Julie, because your critical experts are kind of an essential part of your case, and not having them available and not having them at the trial, it's no bueno.
Right. Yeah, D-. Yeah, that may be generous, Franz. That's a good grade. That's a good grade for her. Casey, what do you think on that point?
If there was anything lower than an F, that is what she's deserving of. You know, I always say that no matter what, a pro se litigant could never usurp the education, training, and experience of a law school educated attorney. So let's start there. And then second, just like my colleague said, where are you going? What is the rush? When you file a demand for speedy, oftentimes it's strategic, and I do that a lot for strategic purposes. But in this case, Lori, you are serving a life sentence already because, and then her excuses to the court that it precludes her from doing certain things based on her housing confinement. This is why Gideon v. Wainwright, the landmark case, it affords indigent clients or those who cannot afford counsel the ability to have an attorney. I do not feel sorry for her. She's doing this all for attention. This is going to be a speedy conviction, and she is doing horrible when she has standby counsel, which she should just wave the white flag and let a law school educated attorney who is barred and licensed to do their job, because she's not doing herself any good by representing herself.
Casey, tell us how you really feel. I'm loving this conversation with you too. I got another clip for you both. Let's look when the issue comes up about her possibly testifying. Let's see her short exchange with the judge now.
I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions.
Okay, but she kept it brief, as you saw, just one word. No, not prepared to talk about this at this point. Franz, how would you grade her on that?
That actually was pretty good. I'm okay with not forcing my hand as a defense attorney. You know, she has no obligation to testify, but the judge telegraphed something that a good attorney would advise her, which is, hey, these other convictions aren't going to come in unless you get on the stand, which the rules of evidence let them come in if you get on the stand. So maybe you should not get on the stand. So I will say that was a good job on her part. I will give her an A on that. That was the right answer.
Nice, nice, Franz. Thank you for that. Casey, do you agree? A on that point to not give it away?
She still gets an F because
not moving off that F.
simply because she still insists on representing herself, and she didn't catch what the judge was throwing. That if you do testify, and really, this is a losing case because she has to testify to explain, what the allegations are against her and come up with a reason why she was not involved. But those convictions are coming in, and let me tell you, those convictions are absolutely terrible for her defense. So he's trying to throw her a bone. And then on top of that, you're representing yourself. So it's going to be in a narrative form, and it's just not going to come off cohesive. And it's going to do her a grave injustice. So because of that alone, even with that one simple response, she still gets an F. And she has time to withdraw her demand for speedy and seek counsel. And I hope she's listening to this.
Yeah, you're so right. Let's talk about that. Franz, let me go back to you on that. Clearly, she needs help with her bad grades. She needs a tutor. She needs something. Tell me, what should she do? Like Casey said, there's still time to not do this. What can she do right now to help herself?
So if I were her, I would say, Judge, I'm in over my head. I do want to exercise my constitutional right to counsel, and I would like to use the standby counsel who, as we've stated, are licensed attorneys who, by the way, they have an ethical obligation to zealously defend me. So I'm going to put them in play. I'm going to withdraw my speedy trial motion because really there's no benefit to that for her. And I'm going to try to put my best case forward. I'm going to try to get those witnesses. I'm going to communicate with my attorneys and tell them what I think is important. But ultimately, I'm going to let them be the drivers of the ship.
I love it. Great advice. Like Casey said, I hope she's listening. We know she watches court TV because she doesn't like what she calls the commercial with her and Chad. She says it's unfair. She put herself in that courtroom in Idaho. We did not. We just filmed it. Casey Early and Franz Borghardt, you two are the best.